Let us now focus on the next section of the Occupational Health and Safety Act, Section 13, the duty to inform. Every employer also has a duty to inform every employee. In Section 13 of the OHSS Act, it states that without derogating or taking away from any specific duty imposed on an employer by this Act, every employer shall, as far as is reasonably practicable, cause every employee, each and every single employee, this is a more personal level, every employee to be made conversant with the hazards to his or her health and safety attached to any work which they need to perform. They also need to be made conversant with the hazards that are attached to any article or substance which this employee needs to produce, process, use, handle, store, or transport, as well as the hazards attached to any plant or machinery which the employee is required or permitted to use, as well as with the precautionary measures to keep them safe. What precautionary measures must be taken by the employee and observed with respect to those hazards. This section of the OHSS Act is more specific to being individual. An employer has a responsibility to ensure that every employee, not just in general, but specifically, every employee needs to know the risks and hazards attached to all of their scope of work, as well as the precautionary measures that must be taken to protect themselves. Section 13b says that an employer must also inform health and safety representatives concerned beforehand of inspections, investigations, or formal inquiries which he has been notified of by an inspector. This would be an inspector from the Department of Labor, and of any application for exemption made by him in terms of Section 40, as well as informing health and safety representatives as soon as reasonably practicable of the occurrence of an incident in the workplace or section of that workplace for which that health and safety representative has been designated. For more information on occupational health and safety representatives, please be sure to get in touch with OHSS Consulting for the course on identifying what is a health and safety representative, what are the representation activities concerned that is outlined in Section 18 of the OHSS Act, and how is a health and safety representative supposed to perform these duties within a company. Why not ask OHSS Consulting to assist you with this course if you have been appointed as a health and safety rep, or if you need to appoint a health and safety rep. Here are a few areas of information that employers need to inform their employees. The emergency procedures, who the first aider is, and the location of first aid stations. What the health and safety responsibilities are for an employee, as well as those that are included in specific legislation. How to report injuries, unsafe conditions, and unsafe acts. How to use personal protective equipment. That they have a right to refuse hazardous work. What hazards, including those outside their own working area. What the reason is for each health and safety rule. Each individual's specific roles and responsibilities, as well as their scope of authority and job description. The following section is very important for employees. Section 14 of the OHSS Act discusses the general duties of employees at work. Section 14 of the Occupational Health and Safety Act states that there are certain general duties of employees at a workplace. So speaking to all of you employees, what must you do in terms of the law? Firstly, it states that you must take reasonable care for your own health and safety. Then you also need to look out for the health and safety of other persons who may be affected by what you do at work or what you do not do at work. Then, as regards any duty that is imposed on your employer, as you've seen in Section 8 of the OHS Act, the duties that your employer has to yourself as an employee, or any other person that your employer has appointed, such as your 8.2E or 8.2I supervisor. What do you need to do as an employee? You need to cooperate with your employer or any person that has been appointed in order to ensure that their duties or the requirements of their duties are carried out. And then you need to ensure that as you work safely, you also perform your work in accordance with any occupational health and safety duty that they have imposed upon them. You need to carry out any lawful order given to you. You need to obey the health and safety rules and procedures. You also need to ensure that any person who has been appointed or authorized by your employer to give you information in the interest of health and safety is obeyed. The information is complied with, and that you carry out these orders given through to you. Now, if a situation while you are working and you notice that currently while you are doing your work, something is unsafe or there's an area that becomes unhealthy, if you notice this, you need to, as soon as practicable, report this situation to your employer or to the health and safety representative that is working with you. We need to ensure that all of this information is also given to our employer or health and safety representative so that it can be rectified. But if you are involved in an incident or an accident, so you actually are working unsafely or you are in an unsafe situation and you get injured, what you need to do is, as soon as possible, report this incident or to any person who is authorized, any supervisor or manager or your health and safety representative. But we also ask that you do not wait to report it. Please report any incident that you're involved in as soon as possible. If it is not possible that you report it straight away, then do not wait until the next day. You must report it by the end of your working shift, so that everything that you do during that incident or accident that occurred can be notified to the employer, to a health and safety representative, or to the supervisor, so that they can put in precautionary measures so that nobody else gets hurt. Now, if you as an employee are working on site and you do get hurt, I'm sure you don't want anybody else to get hurt. And so the record of this incident or accident needs to be made up, and then the employer will designate someone who will investigate what happened. Now, this is not to lay blame on you or any other person who was involved in the incident, but it is to ensure that that incident or accident doesn't happen again. Now, if something happened and it was very serious, then the law states that your employer has a duty to report this to the Department of Labor. They are not reporting you to the Department of Labor, they are reporting the situation, the dangerous situation that happened on site. And so all of that information is necessary for the employer to know and understand, to be given to the health and safety representatives or supervisors or managers, so that they can take this information and tell the Department of Labor what happened. This is a legal requirement of your company. So please ensure that if there is any situation that you are aware of that is unsafe or unhealthy, please report this to your employer. And then, If you are involved in anything that is unsafe or unhealthy, please also report this to your supervisor, your manager, or your employer as soon as possible. So we have seen that it's not only an employer who has the responsibilities toward health and safety, but employees also have responsibilities. And Section 14 of the OHS Act outlines those duties of employees at a workplace. So when it started and said that you as an employee are responsible for your own health and safety, was this a little confusing? Because we just discussed in Section 8 that the responsibilities are on the employer to provide a safe working environment, to provide training, risk assessment, supervision. Does this mean that you now have to be responsible for all of this? Not at all. What Section 14 is telling us is that all the procedures that have been designed by your employer to keep you safe can only keep you safe if you follow them. So very simply, your responsibility is to make sure that you know and understand all the safety procedures for your company, all the safety procedures for the work that you do, the tools that you use, the equipment and materials you use, and then follow these procedures correctly. But it also goes a little bit further. It says that you also need to follow these procedures and look out for the health and safety of any other person who may be affected by what you do. What does this mean? Well, very simply, it means that the work you perform has specific procedures to keep you safe. And if you work safely and properly with these procedures, then you will no doubt be protecting the person next to you, who is working alongside you, who is also exposed to the risks and hazards that are near you. And so you then can comply with Section 14, the duty and responsibility of employees toward health and safety, by protecting your own health and safety as well as those around you. Section 15 of the OHS Act discusses the duty not to interfere with, damage, or misuse things. Section 15 of the Occupational Health and Safety Act states that every person in a company has a duty not to interfere with, damage anything, or misuse anything. It very clearly states, no person shall intentionally or recklessly interfere with, damage, or misuse anything which is provided in the interest of health and safety. Intentionally means we do something on purpose or deliberately. Recklessly means doing something without regard to the danger or the consequences of one's actions. The law then is very clear. We should never do anything to the safety aspects of our work that could interfere with or damage anything that is in the interest of health and safety. Thus, it would no longer protect you or any other person. So we should never misuse anything that is provided for our safety. Let us now take a look at the legislation surrounding health and safety representatives. According to Section 17 of the OHS Act, employers who employ 20 or more workers on premises must appoint representatives to monitor health and safety conditions. One of the key principles of the OHS Act is that work-related hazards, risks, and dangers should be addressed through good communication between management and employees. Appointed representatives represent workers regarding safety and health matters to management. Representatives form part of an important link between management and the rest of the organization's employees. It is important to note that the appointment of a health and safety representative is a legal requirement. Health and safety representatives need to be designated in writing for a specific period of time. The appointment of health and safety representatives should be done in accordance with the agreement as contemplated in the General Administrative Regulation 6 of the OHS Act. We will also look at the duties of health and safety representatives in Section 18 of the OHS Act. Should a company have more than one health and safety representative, then a health and safety committee will be established according to Sections 19 and 20 of the OHS Act. We start off our legal structure for the appointment of a health and safety representative with the General Administrative Regulation 6. This discusses the negotiations and consultations before designation of health and safety representatives. The employer shall, in any workplace where there must be a health and safety representative in terms of Section 17.1 of the Act, and within 4 months after the commencement of these regulations, or after commencing business, meet with the registered trade unions of that workplace in order to consult or bargain in good faith and conclude an agreement concerning the A. Nomination or election of health and safety representatives, B. Terms of office of health and safety representatives, and the circumstances and the prescribed manner in which they may be removed as health and safety representatives, C. Manner in which vacancies are to be filled, D. Manner in which health and safety representatives must perform their functions in terms of the Act, and E. Facilities, training, and assistance that must be provided to the health and safety representative in terms of Section 18.3 of the Act. Provided that where there is no registered trade union, the employer shall enter into consultation with all employee representatives in that workplace in order to conclude an agreement with regard to Subregulation 1. An agreement referred to in Subregulation 1 may include 2 or more employers as parties to the agreement. The conditions applicable to collective agreements in terms of the Labor Relations Act, read with the changes required by the context, shall apply to agreements concluded in terms of Subregulation 1. A dispute shall exist if no agreement in terms of Subregulation 1 is concluded on the arrangement and procedures for the nomination and election of health and safety representatives at a workplace. If a dispute exists in terms of Subregulation 4, any party to the dispute may refer the dispute to the CCMA or Bargaining Council. If a dispute is referred to the CCMA or Bargaining Council under Subregulation 5, the CCMA shall attempt to resolve it through conciliation. If a dispute remains unresolved, any party to the dispute may request that it be resolved through arbitration, in which case the CCMA shall, taking into account the objectives of the Act and the proposals of the parties, determine the arrangement and procedures for the nomination or the election of health and safety representatives. So this means that health and safety representatives should be appointed once a company has reached 20 or more employees. If a company already has 20 employees and has not yet appointed a SHE-Rep, they must within 40 days of starting that business, or 40 days of when the regulations were passed, appoint a SHE-Rep. Companies should meet with registered trade unions or bargaining councils to discuss the process for nomination and election of a health and safety rep, as you have seen in General Administrative Regulation Section 6. If there are no unions or councils, then the employer will discuss these items with all employee representatives. The conditions applicable to collective agreements in terms of the Labor Relations Act apply to these agreements as well. So if an employer cannot come to an agreement with employees, then this is referred as a dispute, and a dispute can then be referred to the CCMA or a bargaining council to be resolved. If it is still not resolved after this, then it may be sent for arbitration as well. Let us now take a look at the Section 17 of the OHS Act to discuss health and safety representatives. Subject to the provisions of subsection 2, every employer who has more than 20 employees in his employment at any workplace shall, within 4 months after the commencement of this Act, or after commencing business, or from such time as the number of employees exceeds 20, as the case may be, designate in writing for a specific period health and safety representatives for such workplace, or for different sections thereof. An employer and the representative of his employees recognized by him, or where there are no such representatives, the employees shall consult in good faith regarding the arrangements and procedures for the nomination or election, period of office, and subsequent designation of health and safety representatives in terms of subsection 1. Provided that, if such consultation fails, the matter shall be referred for arbitration to a person mutually agreed upon, whose decision shall be final. Provided further that if the parties do not agree within 14 days on an arbitrator, the employer shall give notice to this effect in writing to the President of the Industrial Court, who shall, in consultation with the Chief Inspector, designate an arbitrator, whose decision shall be final. Arbitration, in terms of subsection 2, shall not be subject to the provisions of the Arbitration Act of 1965, and a failure of the consultation contemplated in that subsection shall not be deemed to be a dispute in terms of the Labour Relations Act of 1956, provided that the Minister may prescribe the manner of arbitration and the remuneration of the arbitrator designated by the President of the Industrial Court. Only those employees employed in a full-time capacity at a specific workplace and who are acquainted with conditions and activities at that workplace or section thereof, as the case may be, shall be eligible for designation as health and safety representatives for that workplace or section. The number of health and safety representatives for a workplace or section thereof shall, in the case of shops and offices, be at least one health and safety representative for every 100 employees or part thereof, and in the case of all other workplaces, at least one health and safety representative for every 50 employees or part thereof, provided that those employees performing work at a workplace other than that where they ordinarily report for duty shall be deemed to be working at the workplace where they so report for duty. If an inspector is of the opinion that the number of health and safety representatives for any workplace or section thereof, including a workplace or section with 20 or fewer employees, is inadequate, he may by notice in writing direct the employer to designate such number of employees as the inspector may determine as health and safety representatives for that workplace or section thereof, in accordance with the arrangements and procedures referred to in subsection 2. All activities in connection with the designation, functions, and training of health and safety representatives shall be performed during ordinary working hours, and any time reasonably spent by any employee in this regard shall for all purposes be deemed to be time spent by him in carrying out of his duties as an employee. Health and safety representatives are employees who have been elected and appointed as a representative of the employees to the employer on matters of health and safety. We will discuss this more in the course Describe the Functions of the Workplace Health and Safety Representative. But in short, a company that has 20 employees must go through the process of nomination, election, and appointment of a health and safety representative, often called SHE-REPs. This stands for Safety, Health, and Environmental Representatives. Environment here refers to the working environment and not necessarily the natural environment, comprising of animals, plants, and the like. The OHS rep is nominated and elected by other employees and not by the employer.
This is done after consulting with the employees and allowing them to nominate persons who they feel would best represent them. Then, an election is held. The nominated names of the persons are read out and then one of them with the most votes is elected. For formal and legislative requirements, this person is then appointed using a legal appointment and are given specific duties and responsibilities to carry out on behalf of the employee's health and safety. The appointment should have the date of appointment, the period of appointment, the area, section of or business where the person will be appointed for. When an employer discusses the nomination and election of a health and safety rep and no agreement is possible, there are arrangements to speak to government to help and intervene in the agreement. Who can be elected as a health and safety representative? Only employees who are employed at the company in a full-time employment capacity and who know the conditions and activities at that workplace. So they must know the hazards and risks of the work being done. The number of health and safety representatives for a shop and office must be at least one health and safety representative for every 100 employees or part thereof. And for other workplaces, at least one health and safety representative for every 50 employees or part thereof. A health and safety representative can perform their duties during normal working hours and should not need to work extra hours to make up for any lost time away from their normal or ordinary work. What does this mean? Well, if you are appointed as a health and safety representative and you are also the team leader, plumber for your team, then when you have a deadline for an installation of a geyser but also need to complete a register for occupational health and safety, then you must be given extra time to be able to complete both your work and your responsibility. Employers must give you what is necessary to be able to fulfill your role as an employee and a health and safety representative. If a Department of Labor inspector feels that you need to have a health and safety representative even though you only have 10 employees, they may instruct you to appoint one, and they are allowed to do this based on their knowledge of risk and potential need for a health and safety representative at your company. Now we will have a look at section 18. This will discuss the functions or the duties of a health and safety representative. A health and safety representative may perform the following functions in respect of the workplace or section of the workplace for which he has been designated, namely, review the effectiveness of health and safety measures, identify potential hazards and potential major incidents at the workplace, in collaboration with his employer, examine the causes of incidents at the workplace, investigate complaints by any employee relating to that employee's health or safety at work, make representations to the employer or a health and safety committee on matters arising out of paragraph A, B, C, or D, or where such representations are unsuccessful, to an inspector. Make representations to the employer on general matters affecting the health or safety of the employees at that workplace. Inspect the workplace, including any article, substance, plant, machinery or health and safety equipment at that workplace with a view to the health and safety of employees at such intervals as may be agreed upon with the employer, provided that the health and safety representative shall give reasonable notice of his intention to carry out such an inspection to the employer, who may be present during the inspections. Participate in consultations with inspectors at the workplace and accompany inspectors on inspections of the workplace. Receive information from inspectors as contemplated in section 36, and, in his capacity as a health and safety representative, attend meetings of the Health and Safety Committee of which he is a member in connection with any of the above functions. A health and safety representative shall, in respect to the workplace or section of the workplace for which he has been designated, be entitled to visit the site of an incident at all reasonable times, and attend any inspection in loco. Attend any investigation or formal inquiry held in terms of this Act. Insofar as is reasonably necessary for performing his functions, inspect any document which the employer is required to keep in terms of this Act. Accompany an inspector on any inspection. With the approval of the employer, which approval shall not be unreasonably withheld, be accompanied by a technical advisor on any inspection, and participate in an internal health or safety audit. An employer shall provide such facilities, assistance, and training as a health and safety representative may reasonably require and as have been agreed upon for the carrying out of his functions. A health and safety representative shall not incur any civil liability by reason of the fact only that he failed to do anything which he may do or is required to do in terms of this Act. What does this mean? All health and safety representatives have certain duties and responsibilities to carry out. Based on what we read in section 18.1 and 18.2, there are many duties and responsibilities that can be given to the health and safety representative. The appointment of this health and safety representative must explain what these duties and responsibilities are, but also allow for the time to be able to carry out these duties and responsibilities. It is noteworthy that this person may not have any health and safety qualifications. So what is done now? Well, remember, we discussed Section 8 in this Act, the duty of employers, and under Section 8.2e, it states that an employer must provide such information, instruction, training, and supervision as may be necessary to ensure, as far as is reasonably practicable, the health and safety at work of his employees. This means that newly appointed health and safety representatives would need to have training to know and understand how to carry out their responsibilities. This type of training, often referred to as competency training, is needed for all legal appointments. Some training can be done in-house, and some will require accredited training from a service provider who has the accreditation. It is vital to know which is needed. As a health and safety representative, you cannot incur civil liability. This means that another employee cannot sue you or take you to court for anything that you may or may not do in accordance with your appointment and duties set out in this Act. Please find the difference between civil and criminal liability in the course Legal Liabilities. Remember, if there are more than 2 health and safety representatives in a company, then that company must institute a health and safety committee and ensure its establishment. This is handled in Section 19 of the OHS Act under Health and Safety Committees. An employer shall, in respect of each workplace where 2 or more health and safety representatives have been designated, establish 1 or more health and safety committees and, at every meeting of such a committee as contemplated in subsection 4, consult with the committee with a view to initiating, developing, promoting, maintaining, and reviewing measures to ensure the health and safety of his employees at work. A health and safety committee shall consist of such number of members as the employer may from time to time determine, provided that, if one health and safety committee has been established in respect of a workplace, all the health and safety representatives for that workplace shall be members of the committee. If 2 or more health and safety committees have been established in respect of a workplace, each health and safety representative for that workplace shall be a member of at least one of those committees, and the number of persons nominated by an employer on any health and safety committee established in terms of this section shall not exceed the number of health and safety representatives on that committee. The persons nominated by an employer on a health and safety committee shall be designated in writing by the employer for such period as may be determined by him, while the health and safety representatives shall be members of the committee for the period of their designation in terms of section 17.1. A health and safety committee shall hold meetings as often as may be necessary, but at least once every 3 months, at a time and place determined by the committee, provided that an inspector may by notice in writing direct the members of a health and safety committee to hold a meeting at a time and place determined by him. Provided further that, if more than 10% of the employees at a specific workplace has handed a written request to an inspector, the inspector may by written notice direct that such a meeting be held. The procedure at meetings of a health and safety committee shall be determined by the committee. A health and safety committee may co-opt one or more persons by reason of his or their particular knowledge of health or safety matters as an advisory member or as advisory members of the committee. If an inspector is of the opinion that the number of health and safety committees established for any particular workplace is inadequate, he may in writing direct the employer to establish for such workplace such number of health and safety committees as the inspector may determine. What does this mean? If a company has elected 2 health and safety representatives, then they automatically become a health and safety committee. A committee means a group of people appointed for a specific function by a larger group and typically consisting of members of that group. Since there are now 2 health and safety representatives, they will need to hold committee meetings to discuss between them the complete functioning of all employees' health and safety. What do they discuss? All health and safety related information with a view to initiating, developing, promoting, maintaining, and reviewing measures to ensure the health and safety of employees at work. Have a look at Section 20, Functions of Health and Safety Committees, to see how this can be done. All health and safety representatives must be appointed as a committee member and must belong to at least one health and safety committee, as some companies may have many health and safety committees. Take for instance a company with a lot of branches. Each branch may have their own health and safety representatives and health and safety committees. Each branch's health and safety representative would then belong to the one where they report for work. Sometimes you can appoint a person who is not a health and safety representative to be a part of the health and safety committee. If this is the case, then there must always be the same amount of health and safety representatives or more than the non-health and safety representatives committee members. Committee meetings can be held as often as possible, but must be held at least every 3 months. The format of this meeting must be decided on by the committee members and developed into a health and safety committee meetings agenda and minutes. This is kept as proof of meetings as well as records of the functions being carried out by each health and safety representative. Records help us to see what has happened, what is happening, and gives us a good outline to see if we are successful in carrying out our responsibilities. Let us say, for instance, that incidents of damaged tools were occurring at your workplace, and the health and safety representative was informed of the incident. Then it happened again. This would be a red flag, wouldn't you agree? Something should be done. If nothing is being done, and the incident is going to continue to harm people, you would no doubt want something to be done to protect you. If the health and safety reps in the health and safety committee cannot do anything because they do not know what to do, they are allowed to appoint another type of committee member as an advisory member. This could be because this person has specific knowledge on how to deal with a subject matter and can assist the health and safety reps to keep a high standard of health and safety. These advisory members cannot vote during a committee meeting and can only advise the committee within their specific scope of knowledge. Even OHSS Consulting, as safety practitioners, are allowed to be a part of your health and safety committee and bring their expertise to your company. Anything can be done to ensure all employees are kept safe. Let us now have a look at the functions or duties of health and safety committees under Section 20 of the OHS Act. A health and safety committee may make recommendations to the employer, or where the recommendations fail to resolve the matter, to an inspector regarding any matter affecting the health or safety of persons at the workplace, or any section thereof for which such committee has been established. Shall discuss any incident at the workplace or section thereof in which or in consequence of which any person was injured, became ill or died, and may in writing report on the incident to an inspector, and shall perform such other functions as may be prescribed. A health and safety committee shall keep record of each recommendation made to an employer in terms of subsection 1A, and of any report made to an inspector in terms of subsection 1B. A health and safety committee, or a member thereof, shall not incur any civil liability by reason of the fact only that it or he failed to do anything which it or he may or is required to do in terms of this Act. The employer shall take the prescribed steps to ensure that a health and safety committee complies with the provisions of Section 19(4) and performs the duties assigned to it by subsections 1 and 2. What does this mean? Similar to the individual roles and responsibilities of each health and safety representative, the Health and Safety Committee may make a suggestion to the employer on what to do to encourage, uplift, or better health and safety for employees. Although it's the employer's right to choose to act on these suggestions or not, if the Health and Safety Committee feel it necessary, they may send a report to the Department of Labor. All reports, once to the employer and Department of Labor, must be documented and kept as record. It is also the responsibility of the Health and Safety Committee to discuss any incident at the workplace in which any person was injured, became ill, or died. We will discuss what needs to be done more in Section 24 of this Act, as well as in the course conduct an investigation into workplace safety, health, and environmental incidents. As a Health and Safety Committee, you cannot incur civil liability. This means that another employee cannot sue the committee or take the committee to court for anything that they may or may not do in accordance with their appointment and duties set out in this Act. Please find the difference between civil and criminal liability in the course legal liabilities. Let us recap. Employers, please remember that you must come to an agreement with the nomination and election of health and safety representatives for your company. You must ensure that you know the terms of office, the circumstances and matter in which they can be removed, the manner in which vacancies are to be filled, the manner in which health and safety representatives must perform their functions in terms of the OHS Act, as well as ensuring that facilities, training and assistance is given to all health and safety representatives.